interim leader of the BC Green Party, and Elizabeth May, the Member of Parliament for Saanich and Gulf Islands.
And leader of the Green Party
and
of
leader
Canada.
of the Green Party of Canada. Thank you for reminding me, of course. Right. Add to that also that Andrew Weaver is the deputy leader of the BC Green Party, just to make it official. They are here today to talk about the Kinder Morgan Pipeline National Energy Board hearings, to process with the announcement this week that the panelists decided not to have oral cross-examination as part of the hearings. And just to let you know that all three of them have successfully applied as interveners, and that Andrew Weaver is the only BC MLA as an intervener. So to get us started, we'll have Andrew speak, and then Elizabeth May, and then Adam Olsen, and then we'll take questions afterwards. Thank you very much.
Thank you, and thanks for everyone for coming. So we're here today to call upon three different organizations to stand up for British Columbians and actually do the right thing and allow cross-examination process to occur in the Kinder Morgan hearings. This is very unlike the Enbridge hearings where cross-examination occurred. I'm specifically calling on the BC government to join me in asking the NEB and asking Kinder Morgan to do the right thing and allow a cross-examination. In the Enbridge hearings, Northern Gateway hearings, the most important information that British Columbians became aware of came through the government's cross-examination process, where it was during there that they were able to explore some of the answers that were put forward by the Northern Gateway project, which would not have been able to be explored otherwise. This is a means and ways of limiting engagement of British Columbians. It's very troubling because the only mechanism for intervention is through submission of written questions, waiting for written answers, and if you don't like the answer, appealing through a motion directly to the NEB to ask for further clarification. You do not have access to the experts of the Kinder Morgan pipeline proposal, and from my perspective, I've been accepted twice as an intervener, one as a representative of Oak Bay Gordon Head for obvious reasons. The tankers proposed will be coming right behind us they're coming once a week now, but they'll be coming daily. And the other as an expert from my science background, which involves ocean science. And if you cannot question scientists and their scientific papers and analysis and assumptions, it's simply not acceptable. You cannot have people putting forward scientific arguments and not allow scientific questioning of those arguments in an interactive forum, because otherwise the full information is not available. So my call is specifically to the provincial government, asking them to join me in asking for the NEB to include cross-examination as a critical component of intervention status in the upcoming hearings.
Hello, and I want to thank Andrew and Adam for, it's interesting as Greens, federally and provincially, none of us had told the other ahead of time, oh, I'm applying to be an intervener. So when the list of interveners came out, I was like, well, that's great. Andrew Weaver's an intervener, and I'm an intervener, and Adam's an intervener. And then discovering this quite appalling and draconian reduction of the rights of interveners. Now, my background is different from Andrew's. My background is in law, and I first appeared before a National Energy Board hearing as legal counsel in 1981. So I have a lot of experience with the National Energy Board as a quasi-judicial body, and I believe that what has happened with the Harper administration shortening the hearings, which they did through the draconian Bill C-38, the omnibus budget bill, that the interpretation of that by the National Energy Board is not just unfortunate. I believe it is actually a violation of the rules of natural justice, and as such could form the basis of a successful court challenge. I've been in consultation with one of Canada's leading lawyers in this area, Clayton Ruby, and he is willing to, he's now investigating whether we think we should take this to court right away. This only fortifies what Andrew Weaver just said. The National Energy Board should not go this route. It is a mockery of the concept of a hearing process, that there actually be no hearing, that it be an exchange of paper. There is no way to test the strength of the evidence if the evidence is put forward with no cross-examination. So it's outrageous, and if the British Columbia government puts pressure on the National Energy Board, if Kinder Morgan itself agrees that they don't want to go down in history as a mockery of a review, then I think that we can get this changed. In the meantime, if they don't agree to change, I will continue down the route of exploring our options in court.
And I completely agree with my colleagues here. I think the one thing that needs to be added to this is that Kinder Morgan needs to step up, I think, and ask the National Energy Board as well to include oral examinations into this process. They need to be fully transparent. We need to be confident in the information that they're giving us. The only way that we can be confident in that information is if they're willing to have it be tested, and be tested through science, be tested through legal methods. And so it is incumbent upon them, I think, to stand up and say that this process is not a process without oral examination, thorough oral examination, so that we know that the evidence that they've given us is actually factual and stands the tests that those of us that are in the process can put it through. And so Kinder Morgan needs to also ask, in order for this process to hold any water at all, needs to ask for oral examination as well.
Any questions?
Isn't this, in large part, I understand your argument, don't misunderstand, I do understand your argument, but doesn't this speak to the minutiae of government and government bodies that the public largely has been turned off of in politics?
What the actual denial of cross-examination, or I think that from my perspective, this is something that was done by a committee that overstepped their jurisdictional responsibility, as my colleague Elizabeth May has pointed out here. It's historically not been the case. We just have to look earlier this week at what happens when you don't build a social license for a project. We have the BC government last week, probably in cabinet, coming with a order in council to exempt sweet gas and ski hills from environmental assessments. Well, you know, we're like everyone else picking this up and reading it in newspapers and going, what's with this? Well, they rescinded upon that. And what they've done in this process, if they've lost trust going forward, what we're trying to do in this process here is say that, you know, you're just following down the same path. You have to build trust, not lose it off the get-go. I think Northern Gateway lost trust from day one with the way the whole process went forward, and this is going to be the same as we move forward down this Kinder Morgan. The way to start off is with a cross-examination.
Yeah, I just want to say it's not minutiae. I mean, every single time I have a town hall meeting anywhere on Vancouver Island, the number one thing people want to know is how are we going to prevent super tankers or Aframax tankers loaded with bitumen and diluent up and down our coastline. It's too big a risk to take. That's why I applied to be an intervener. In my intervener statement to the National Energy Board, I said I'm representing my constituents in their concerns, and what they've done is give us an opportunity that can't be used. And an opportunity that can't be used makes a mockery of the process. So they've said, yes, all right, as a member of Parliament for Saanich Gulf Islands, you're allowed to be an intervener, but we won't let you use that opportunity effectively. So I think that whether people, you know, as the average citizen doesn't really think a lot about quasi-judicial bodies and whether cross-examination is an inherent right to have all of the panoply of tools that have been developed over centuries in this process in British common law. But as somebody who represents my constituents as forcefully as I can, I'm certain that my constituents really want me to fight this decision because it does violate it and it does undermine our ability to make the case that we must protect our coastline.
These are just to add to that, these discussions are complex, and unfortunately politics has dumbed these discussions down to 2 or 3 key messages, and you come out and you deliver those messages, and that's what politics is. These are nuanced discussions. These are very important discussions for us to be having in their entirety. And I think that actually people will get more engaged in politics if we as leaders can turn around and say, this is what we need to be discussing as a society in its entirety, not here are 3 or 4 points that'll make you feel good and have a nice day.
If I could give a very specific example. What became clear in the Northern Gateway hearings is that there was very little, if any, research done in terms of what happens to dilbit being spilt in the ocean. Well, in fact, we do have the federal government, DFO, Transport Canada, NRCan, issued a report in the fall that pointed out that in the presence of suspended particulate matter, dilbit can actually tarball up and sink. Now, what we know we have no shortage of in the Fraser River estuary is suspended particulate matter, and this is the probing that I would do from a scientific background. So what is the evidence that Kinder Morgan could bring to the table to argue that suspended particulate matter in the Fraser River will not tarball up the diluent if it were to spill, the dilbit, and create a base of the ocean devastation? And in a scientific discussion, they may point to a study and say, we've done it here. Well, what you do in science is you then go to that study, you analyze it, and you follow up with questions on the assumptions that are in the study. That study may be done in a lab tank of fresh water. It may not have been done with suspended matter from river sediment. So these are the type of probing questions you get in a cross-examination from a scientific perspective that are simply absent. It's a trust us, we've done it information, go away and be quiet kind of approach, and that is not acceptable.
Well, and to add on to that, that information that Andrew just outlined is exactly the kind of information that the government of British Columbia based their evidence on, coming to the conclusion that they couldn't support Northern Gateway Enbridge at this stage. So it's that cross-examination that was the foundation of their opposition to that pipeline.
Okay.
Any
Covers
other
it for me?
questions?
No, that works for me. Thank you.
Il y a personne ici pour en français? No. So we're going to defend our coastline. We don't care what they try to do to tie our hands. We're defending our coastline. And we will do it. Thank you.
Thanks.
Thank you, everyone.
Thanks.
Very much.
Thanks, Matt.